As people start to filter in, just letting you know, we'll wait another minute or so before we get started.
Okay.
Well, hello, everyone. My name is Christina Carroll, and I am one of the DAYL Judiciary Committee co-chairs, and I am honored to be moderating this last session of Getting to Know the Courts. We first would like to recognize our platinum sponsors, Ackerman, Bell Nunnally, Burke Bogdanovich, Cobb Martinez Woodward, Dorsey and Whitney, Ferguson, Braswell, Frazier, Kubasta, Greenberg Trarig, Hartline Barger, Kane Russell Coleman Logan, Castle Law, Lynn Pinkerhurst and Schwegman, Lyons Simmons, Platt Chima and Richmond, Ryan Law Partners, and also our gold sponsors, Aiken Gump, Strauss, Hauer, and Feld, Harrington, Coleman, Sloman, and Blumenthal, Reese Marcados, Van Way, Presby, and Williams. So thank you to all of those sponsors for making this entire series a success and possible. I will stop talking in a little bit and let our panelists take over, but there are two other mentions for you out there. Remember to use the Q&A feature in Zoom to pose any questions to the panelists. And then we will also post the CLE course number for the end of the session, so be sure to stick around. Okay, without further delay, I would like to introduce Senior Justice Deborah Lehrman and one of her most recent former law clerks, John Ormiston. Thank you both for being here today to introduce us to the Supreme Court of Texas.
Thank you for having us.
Absolutely. We had talked beforehand, and of course we have a lot to cover today, so we'll go ahead and dive right in. Let's start with a lawyer brings a petition to the court, a petition for review. How does the court decide whether to grant a petition?
Well, there's a process, and we call it the conveyor belt process. The petitioner, of course, wants the case to stay on the belt, and the respondent wants the petition to get taken off of the belt. There are about approximately 20 to 30, sometimes 40, sometimes 15, it varies, but it seems like generally about 25 to 30 petitions filed per week that the 9 of us individual justices review. And it's kind of the hidden thing that we do because nobody's really seeing it out there in the open. But we vote on those every single week, 52 weeks a year throughout the year. So when people ask me, are you on vacation? I just kind of laugh and say, no, because we vote on those petitions every single week. If only one person of the justices asks for a response or asks to discuss the case at the next conference, then that case will stay on the conveyor belt. But if all 9 of us vote to deny review, then it goes away, goes off the conveyor belt. About 1/3 of the cases are disposed of at that time. Now, let's say it's not disposed of, and that means that we either are requesting a response, which means then there's going to be time for the respondent to file something, or we're just going to discuss it at the next conference. And let's say if it's a case that I think is important to the jurisprudence of the court, of the state, but nobody else has asked for a response or to discuss, if I can convince 2 of my colleagues that this is an important issue, then we will then request full briefing from everyone, from all parties, and we will assign a study memo to one of the chambers that's just randomly in order of seniority assigned, and then we will do our own internal briefing. That's a big job that the clerks do, is prepare those study memos. They will come up with a recommendation And then at the next conference, after that internal briefing and all the full briefing has come in, then we will discuss again. And if I can get 3 of my colleagues for a total of 4 votes to grant, then we will grant review of those petitions. But it takes more for us to, we may be able to do a per curiam opinion on it without oral argument, where we will actually grant in the sense that we're going to write on it, but we're not granting oral argument. But typically it takes the 4 for us to grant review.
I want to make sure I have it clear. Uh-oh, I think excuse me, I'm hearing a little feedback. I apologize. So there's the 1 vote and the 3 vote before the study memo. And then after the study memo, there's the vote for oral argument or a per curiam opinion.
Correct.
Are there any types of cases that take priority over the others, or any kind of case that's more likely to be granted, or petition, I should say?
Well, I mean, one of the main criteria for us to grant review is that the issue has to be one that significantly impacts the jurisprudence of the state. We are not a court of error correction, although some of that goes on. But for example, we may think that a lower court got something wrong, but if it's an issue that doesn't significantly affect the jurisprudence of the state, then we may deny review. And I think that's kind of gets misunderstood, because a lot of times I will hear lawyers discuss at CLEs, well, the court didn't grant review of blank case, and therefore they are, endorsing, affirming, supporting that opinion or that decision of the lower court. That's not true. It may very well be that we didn't grant review for a variety of reasons, which may be that it was not a significant issue. It may be that it's as simple as that the briefing was poor. There's a lot of reasons that we may not grant review.
Speaking about poor briefing, from the both of you, do you have any tips on what to include in a petition for review, or what to avoid including that might help your chances?
John, you want to go for that one?
I would kind of echo what the judge just said about not emphasizing a perceived error that the Court of Appeals made, as much as saying this is important because these facts are likely to recur, or there's a split with another Court of Appeals here, so now the law is fractured. Those are the things that I think are more likely to get the court's attention than just saying, the court really screwed this one up. If you have the umpteenth case under this same statute that comes up all the time, and courts just exercise their discretion in different ways, the Supreme Court might not be eager to jump on that, because that's just the system working. But if you have something that poses a problem going forward, that's what you need to emphasize. And then the other tip, I think brevity is always appreciated, especially in the petition. Just put it out there up front.
Yeah, remember that we read a lot. I mean, we have, like I say, the petitions, which are, they're word limits now, but it's approximately 15 pages per petition. The reason we changed it to word limits was so that people would be encouraged to include charts and things like that, because it's helpful for us to understand what's going on. There's just a whole lot of reading going on, because there's the petitions, and then there's the study memos, and there's all of the briefing on both sides, and the cases, and just everything that's involved in researching an issue. And then on top of that, we do our own writing, and then we're reviewing other writings. So there's a lot of reading going on. So you want to get our attention. And so a lot of appellate specialists call it develop a hook, think of something that's going to get our attention and say it succinctly and briefly, but in a way that's going to really make the point and avoid hyperbole. If you say the sky is falling, it's not very persuasive.
Sure.
Because rarely is the sky really falling.
What is the difference between full briefing and a petition for review?
John, you want to take that?
It's really just a matter of, length and depth. One is just flagging the issue, and then the other is you're, putting out all your arguments, all your cards on the table, because ultimately the court is going to rely on the full briefing when they're conferencing, when they're preparing for oral argument. That's what's going to inform the writing of the study memo, which is our internal briefing again. So the petition right is just, here's the problem, please ask us to tell you more about it. And then obviously full briefing is the whole thing.
The petition is getting our attention, that hook to get us. And then full briefing is really educating the court about your position of the case in full, just like.
And when you're talking page limits, I believe, so you said the petition would be up to 15 pages based on how the words shake out, the word limit shakes out. And then for full briefing, generally speaking, how long are those briefs?
50 pages. It's a word limit too, but it used to be a page limit. And so I still think of it in terms of pages. But do you know what the exact word limit is, John? I don't, but it ends up being about 15 per petition and 50 per full brief.
Wow, 50 pages. That's not short. Okay, John, if I understand correctly, you as a clerk have quite a bit of experience with these study memos. Can you share with us what the process is for the clerk with creating and providing the study memo and what the purpose is?
Sure. So the way we get assigned them is the court will be going through petitions at conference, which all the clerks attend with the justices. And so when you get the required 3 votes for a study memo, it just goes out to the next chambers in the list of seniority. So it's just to cycle through that. And then within our chambers, our staff attorney would assign one of the study memo to either me or my co-clerk, and we would take it from there. And it's a pretty solitary exercise. The judge has talked about this before, but it's kind of insulated from the court's input. There's no judges telling you what to focus on or what they want to see here or there. It's more of just being as neutral and objective as you can, taking all the arguments and condensing them, summarizing them, and finding the rub, finding what is going to be important for the court to address. And usually you can do that relying mostly on the briefing, but you also are tasked with looking for issues of waiver and error preservation or anything like that that might make it so the court should clearly deny or clearly grant the petition. And so it's a pretty research and time intensive task. I found it stressful at first, but like anything else, I kind of got used to it. And it for as solitary as it can be, your co-clerks can help you out. These are the kind of cases that you stroll into their office about, like, I'm doing the study memo, here's this, and this, and they'll be like, oh yeah, I saw that case's petition. And that's where kind of the collaboration comes in. But like the judge said, when you finish, it comes attached with a recommendation, which the court is in no way bound by and frequently does not acknowledge, but it's
we acknowledge it, we just don't follow it.
Because that's not really what it's about. It's not about the grant or deny that it's at the beginning. It's more of just like, here's the most down the middle look at the entire case condensed into our own internal thing. It's not made by an advocate. And if the case gets granted, the study memo actually sticks around and is a resource for the justices to refer to as the case goes to oral argument and eventually an opinion is written.
They're very important. I mean, the court really, really depends on the study memos a lot. And the fact that we don't have input, we could. I mean, there's no rule that we don't. And every once in a while, one of us may go to whoever's writing the study memo and just make sure that they look at blank or whatever, depending upon what the issue is. But we really want an independent analysis of this legal issue that is not trying to go one way or the other, that is just correctly interpreting the law as it is in this particular case, free of any kind of bias one way or the other. And so for that reason, we very intentionally are not involved usually in that stage of the process. But we always have to tell the clerks, especially at the beginning. John can maybe comment on this a little bit. Don't get all tied up in knots about your recommendation, because that's not really the biggest part of this. And don't get your feelings hurt if we don't follow it, because that's just how it works. It doesn't have anything to do with whether you were right or wrong, because the recommendation is the most minor part of it. It's going through the whole analysis and also double checking everything that's in the briefing from both sides to make sure everything that they have articulated is accurate in terms of the record and the case law.
So where does the oral argument come into play? If we're talking about the conveyor belt, and again, excuse me, but just to rehash, you have the petition come in, there's potentially a discussion, you have the votes for the full briefing, you do the study memo, and then you go back and discuss whether you're going to have oral argument. Is that right?
Well, yes. And it takes 4 votes for oral argument. And so then at that point, the cases are assigned to individual chambers. And the way that we do that is very low tech. Our chief operating officer prepares blue index cards with the name and the cause number and puts them down, face down, and we draw starting with the person with the justice with the least seniority, and we go around the table. And it's really a great way to do it because it's free from any kind of game playing. If somebody like the chief, whoever's the chief at the time, were assigning the case, then different factors could come into play, which they do in other courts that do it that way. But we draw them randomly. So when you pick that case from where, you can only blame yourself because you picked it. So we know when we go up on that bench, which case has been assigned to whom. Now that we have all, 9 of us, for every case, read all the briefing, read all the seminal cases, read all the internal briefing, but we also know who's been assigned that case. After oral argument, we usually have conference the next week. And so we will all do post-sub memos on our particular case and any other case that we want to do a post-sub memo for. And those are circulated the week before, usually the weekend before the conference. And so then during conference, say if it's my case that's been assigned, I will explain the post-sub memo, which indicates what my view of the correct application of the law is and how this case should turn out. And then we go around the table and get other opinions. Everything is in order. Everything's very formal in conference. We sit in a certain order that we go across the table from seniority, and then we go around the table in terms of who's talking about the case. So if it's my case, I speak first. Justice Devine sits to my right, so he's going to speak next, and it just goes so forth all the way around the table. And after that, you have a feel for whether you're going to be able to write the way you think it should be written, or whether you're going to have to move a little bit one way or the other, or whether or not you may just have to give up the majority and be a dissent, and that's kind of an internal decision within your chambers that you have to make. One thing I don't think a lot of people understand is that, so after that, let's say I write, and let's say a couple of months later, we've got a writing, a first draft, and that's circulated before the next conference. So I'm going to be the first one to talk about it because that's the first writing on the table. We're going to go around the table, and let's say if one of my colleagues says, I disagree with this, I don't think this is the correct application of the law, they can pull that case and to write separately. And if they can convince 4 of my colleagues that they're correct, then they take the majority. And that happens. That happens pretty frequently.
Oh,
And even if that doesn't happen, a lot of times you will be able to work with, let's say if Justice Busby circulates an opinion and I don't agree with certain aspects of it, I may take it to study and I may decide to write separately. But before that, I'll probably go to him and talk to him about my concerns and see if we can figure out what we agree is the correct application of the law. And that happens a lot too.
so what I'm hearing is you never stop being a trial lawyer because you're still trying to persuade a judge. That's wonderful.
Yeah, pretty much. Yeah. There's a lot of that goes on.
I do have some follow-up questions on the oral argument. So you've described just a mountain of reading that you have to do. How, not so much the number of oral argument that you might grant, but when does oral argument happen and how many times do you have oral argument during the day or during the week? Can you give us those kinds of guidelines?
Sure. John, you want to take that one?
Sure. So oral argument is, they come in sets of 9, usually, sometimes fewer, but it'll be 3 days in a row, Tuesday, Wednesday, Thursday, 2 or 3 causes per day. So the court does them in chunks like that, and it's usually once a month through starting in, I believe the first set will be September, because it was right after I started last year. And then, like the judge was saying, after the next conference following that set of oral arguments, they're on the conference agenda for, it's called, they're submitted. If you listen at the end of oral argument, the chief will say the case is submitted. So post submission, the court will have their first round of discussion about it in conference, like the judge was just talking about, and then it'll come back around usually with an opinion draft later. So that constantly is happening through the term because there's always another set of oral arguments happening. So yeah, they come all at once, and if you kind of just like do the math, it's not always the way, but usually each justice for a week of oral argument will have at least one case that they've drawn. So it's definitely like a big deal, and you know, every single week is going to be for every chambers. There's going to be one that your judge is really focused on because it's going to be the one that they're going to draft the opinion.
And how are you involved as a clerk in preparing for oral argument?
So it depends on chambers. I think our chambers has one of the best ways to do it, just because Judge Lehrman is very interactive and lets us kind of participate in preparing. We all meet every morning, the morning of oral arguments, and she asks us to just, you know, look at the case and draft some questions to kind of help frame thinking. And again, you know, it's not about whether is she going to pick one of our questions to actually ask. It's more just like we have our discussion, we warm up on it, and it's just nice to share perspectives on things. And it's nice as a clerk trying to keep, you know, aware of what's going on in the court with all these cases coming through, is I would get assigned these cases to do questions on, and there were ones that I hadn't seen the petition or hadn't run up on, and all of a sudden I get to dive in, read the briefing, read the study memo. And so once it's time later and there's an opinion going around, and maybe your judge is wanting to write separately or something, you're kind of already prepared and you've got a good hand on the pulse of what's going through the court.
Oh, that's wonderful.
And it's a lot of fun, really, because by the time we have our conference, our chambers conference, the morning of oral argument, we get there early. Or now, since it's been on Zoom, we do that early. If one of these days we'll get back in person, I hope. But you know, I have already written out several, you know, areas of inquiry that I want to delve into before I even look at what their questions were. And that's done very deliberately because I want to make sure that that I'm not just looking at this from my perspective. I want to make sure that I have taken into consideration other people's perspective of what's important. And it's interesting because that really can change the way that you think about a certain case, simply because what I was focusing on may be very different than what John was focusing on when we were reading the same documents. We're reading the briefing, we're reading the study memos, we're reading the cases, but what pops out may be different for him than it is for me. And then it's really good to consolidate all that. I always tell people when I interview my clerks, I don't want yes men to work for me. I want people who are going to challenge me to get it right. And so John was great with that. All my clerks have always been wonderful at doing that. But I think that's a very important part of it.
Well, I see that someone raised their hand, and just a reminder, if you have questions, please put those in the Q&A box so that I can see them and present them to the panelists, because we definitely want to get questions answered and cover all our bases here. Another question on oral argument, and this one I've wondered about just across the different levels of appeals. Does oral argument really matter? Does it actually help change anything? Does it influence a decision?
I mean, that's a very common question, because especially, experienced appellate advocates who are exceptional at what they do. They're wonderful. And they know that we have read everything we've read by the time we get on that bench and they're in front of us arguing. And so, the inclination is to think, well, you've read everything. You've discussed this with your brilliant law clerks, how could you not know what you're going to do? But you would be surprised how frequently, even though we have really tried to look at it and gotten input from other people within our chambers to make sure that we are looking at it correctly and analyzing it correctly. But when you get into that courtroom, the way that the attorneys phrase it or what they focus on can be completely different than what we have been focusing on within the chambers, or what the study memo honed in on, or whatever. And so I think it's really happens more than people realize, that process of oral argument really can impact what's going to happen in the case. Did you see anything like that, John? I mean, you were kind of in a different perspective, but you had a different perspective, but you did know at least what we were thinking as a chambers going in. And so what was your view of that?
I definitely think that it matters. I don't think there would be so many, advocates who are so good at it if it didn't. And they know that. And that's really where you can see the needle move, is when people who are very good at their job come in and they don't waste time trying to tell the story of the case, because they know that the judges know the story of the case. The judges are they're already at the point where the rubber meets the road, and they jump right into it and they just say, here's why we're right. And I think a really good presentation in oral argument where you address questions that come your way, because that's really where you can make the hay. When a judge asks a question, they sometimes are signaling, I'm not sure where I am on this. And when you can see an advocate come in and give a really good answer to that, it definitely can have an effect on where the judges are leaning and ultimately where the case comes out.
So it's interesting, because I hear the two of you talking about these experienced lawyers, and I'm sure we all know about the appellate lawyers, and that's what they do. Are there any tips that you have for not so experienced lawyers who might be presenting in front of the court oral argument, maybe the first time or the first several times? I don't know if there's any kind of wisdom you can share on that process.
Prepare. And in fact, when I've heard seasoned appellate lawyers that are the ones that are in front of us regularly, and there's a large group of those. If you look at the advanced appellate seminars that we have both in May and another one in September, they're very highly attended. And a lot of those people are seasoned lawyers who do this a lot. And those people will talk about how when they're preparing for an oral argument, they will get in front of a mirror, or they will get in front of a colleague and start talking about the case, and then and they're intentionally, certainly not the mirror, but when they're in front of a colleague, being peppered by questions, because people also know that we have a very inquisitive court. We ask a lot of questions. And so you're not going to, one thing that I try to, I usually ask the first question or one of the first questions. And one of the reasons for that is because I want to make sure that people are focused on what I know we're thinking about, because we've all read the same study memo and we all kind of know, what was highlighted in that study memo. And so, number one, for people who are not seasoned before us, do not spend time on the facts. Do not spend time on seminal cases or explaining those to us, because we've read all those. We know about all of that. And you only get 20 minutes per side. So it's really going to be a waste of your time. Pay attention to questions that are being asked and answer them. And make sure that you guide us into looking at whatever issue there is before the court that's the issues that are important, in a way that you want us to be looking at it. So make sure that when you're trying to answer that, and you put a lot of hours into this, because think about it, there's a big difference between giving a presentation of something where you're just up lecturing, and giving a presentation where you're constantly being asked questions about these things. And these questions don't necessarily go in any order, because before we get in there, I haven't discussed that case. I may have some early on in trying to convince people to take the case, but once we decided to take the case, I haven't discussed it with any other justices. I've discussed it with my staff. And so those questions can be ranging from jurisdictional issues to waiver issues to a substance on the legal issue, just all over the place. And so, you got to know that stuff backward and forward to be able to answer those questions. So it takes a lot of preparation.
Is there ever a situation where, let me put down my copy again, I apologize. Is there ever a situation where the lawyers didn't consider an issue that the court brought up, and then the lawyers are given an opportunity for additional briefing after oral argument?
That can happen, yeah. Yeah, I mean, if one of the justices asks a question maybe about a case or a statute or something that wasn't just obvious that it was going to be an issue, and the lawyer, or it may be a brand new case that came out that the lawyer's not aware of, then they are able to submit a post submission brief to us, elaborating on whatever that is.
Okay, and so the post-submission brief that the lawyers do is separate from the post-submission brief that we were discussing earlier, where the justices themselves are essentially saying, this is how I think we should rule. Is that fair? Okay. I want to go back to the conveyor belt process. We have a question that came in, and I think it's a great one. How do emergency petitions and requests for review fit into the conveyor belt process?
They don't. I mean, well, okay. So we actually have a lawyer, a mandamus lawyer, who is the lawyer who deals with mandamus petitions and also emergency orders. And as everybody knows, we've had a lot of emergency orders this past year and a half since we've been dealing with this pandemic, and we've had election issues and all kinds of things. And so sometimes those types of things that require immediate action, say for example, an election issue, if we don't deal with some of those issues quickly, then it's going to be too late to get a ballot printed in time for an election. And those elections are set by whatever they're set by, depending upon what it is. And so those are the kinds of issues that sometimes we have to grant emergency relief, and it doesn't just go along the normal course of events. Our CPS cases, our child protection cases, because of the magnitude of what we're dealing with children who are in that very very sad, challenging situation, whether it's from being in an abusive home or being wrongfully removed, either way, is just devastating. And we're very aware of that. And so those cases immediately go to a certain process for quick review. And that's going to come before us faster than other cases. Those are dealt with in an emergency manner.
Thank you. Another question that came in relates to full briefing. So earlier we talked about what kinds of cases might take priority over others, or what the court might really want to address. What about matters of public policy, or if there's wide media coverage, or if it's a political issue? Does that ever weigh into whether to grant a petition, or even later in the process, whether to request full briefing?
No, that would not have an effect on whether we would grant, unless it was something that needed emergency action, like the election thing. It wasn't because those cases were highly politicized or that there was a lot of media attention to those. It is true there was, but that wasn't why we did them quickly. It was because of the emergency nature of needing to get something done before ballots were printed. Same thing with some of the pandemic issues that we had to deal with in terms of making decisions that were really affecting the health and safety of citizens. And so we had to do some of those things in an expedited manner.
That makes sense. Okay, so we've discussed oral argument. You took us through the opinion conference process and how you can sway your colleagues. What is the clerk's role in that stage when it comes to writing an opinion?
John?
Opinion writing is very collaborative. Obviously, the judge is the one whose name is on it, and the judge is making the decisions, but it's definitely, it's a big collaborative process to get an in-depth, long piece of legal writing done that has to be thorough, has to acknowledge all of the other laws around it, has to get the facts right. So it's a big endeavor. It's probably the most challenging thing that you do as a clerk, but also the most rewarding. And it as much as it is a project for your chambers, it is collaborative amongst the court as a whole as well. Judges love to work together and incorporate insights that a judge might bring up in conference, or sometimes you have to put in this footnote to get someone on board with it because they think without the footnote it means this, or with the footnote it means that. It's all kind of a very flowy type process right up until the end. It's very interesting. One of the things I enjoyed the most. And sometimes, you work together to get something almost all the way there, and then you change your mind, or you realize like this isn't the right way to go, and you have to do a lot more work to get it there. But it's one of those things where it's not about being fast, it's about the right answer, which is I think it's not unique to courts. Obviously, private practice cares about getting the right answer, but that was kind of the context I enjoyed seeing, where it was, take your time with it and make sure that we are doing right by the law. Yeah, that's about all I have to say on it. Opinion writing definitely was probably the most memorable part of the term for me.
Well, in a follow-up question, you said that it's the most challenging part, or one of the most challenging parts of being a clerk. And I mean, putting aside the amount of work that goes into it and all the different things that you have to read, what makes it more challenging than the study memo where you're isolated and doing that on your own?
I think it's perhaps more of a pressure thing, because opinions go out and then there's news articles about them, and it's just so public. And the judges are obviously very accustomed to that. They know that they're public figures, and but for me, being involved in something like that definitely took a little bit of getting used to, but it's cool when it eventually comes full circle and you see it out there.
But we are used to it.
Yeah.
How
Or whenever
long?
a
Oh, go
media
ahead.
outlet will report on a case, you know, and they'll say that we did blank and we didn't do anything like that. But you get used to it.
So how long, John, you mentioned also that it's not about the speed, it's about getting it right. How long does it take for the court to actually issue a written opinion, generally speaking? I know it's different for every case.
It really does vary. Some of the cases that get argued in September will have opinions go out in June. So that's 9 months. And then some of the cases will get argued in November and have an opinion out in February. So I would say, and those are.
But that's unusual.
That's unusual, yeah. But I guess those would definitely, yeah, those would definitely be the minority. But it really depends, and I think it's a function of how much agreement there is on the court. The ones that take the longest are the ones where there's more persuasion and a split in opinion amongst the justices.
And it's kind of funny. I know over the years, sometimes there'll be cases that take longer. We clear our docket now by the end of June, and we have for 5 years, and hope that continues. That wasn't always the case. And so sometimes lawyers would complain that a case didn't come out. And, I would always think to myself, well, do they think we forgot about it? That's not it. That means that we are disagreeing a lot. And in fact, those cases, more work is going on those cases, because during that period of time, there's just a whole lot of back and forth. And there's a lot of that. That's also the reason that we quit hearing oral argument typically in March. We have backup oral argument dates always set in April in case we need them, but we try not to do that, because since we get all our cases out by the end of June, that's only leaving April, May, June, 3 months to vet a case, and that's really not long. And so any less than that, and we would be sacrificing accuracy for, I guess, efficiency, but I don't think it really is, because the way we schedule the oral arguments, we make sure we try to front end more of them in fall, when we're not doing as much writing yet, because we're just not at that stage yet of, starting in December. That's when the writing gets really intense, because at that point in time, we're not just doing our own writing, we're reviewing other writings, and we're writing separately on those cases. And there's a lot of that goes on, more than people probably realize. And so you've got and a lot of times we do separate writings that never get published, but they had an effect on the writing that did get published. And there's a whole lot of that kind of stuff that goes on. And so if you have oral argument too late in the session, you're not going to have time to do that go through that very valuable process of challenging each other to get it right.
So when you say there's an April backup date for oral argument, why would oral argument be granted that late? Is it just because a case has been voted on that late, or you're deep in the writing process and you say, oh, we actually need oral argument?
It would probably be something for usually if we do grant on something like that, it's probably a child protection case or something like that we just view that there's a real necessity for us to get this done, because otherwise it's going to wait till the next term. Mm-hmm. And so all the cases are important, certainly. And it's not that any case is more important than others, but when you're talking about children and their future and their lives, because they're so vulnerable and they're so young, then we're going to try to make sure that those cases get taken care of.
Well, I see we have about 10 minutes left, or maybe like 14. And so I want to cover one other aspect of the court that I don't think many people know about. Can you explain the difference between, I believe it's the administrative conference and the merits conference?
Sure, sure. So we have a lot of administrative duties as the head of the third branch of government. So we're over the State Bar of Texas. We're over all of OCA and the judges. We of course have rulemaking authority having to do with the rules of evidence and having to do with the rules of civil procedure and having to do with the disciplinary rules. There's a lot of stuff. BODA, the Board of Disciplinary Appeals. So licensing of lawyers, the bar exam. It really goes on and on. We have a lot of administrative responsibilities. And then during COVID, then we even had more things like that were just kind of piled on. And so at the, usually a big part of conference, of course, is dealing with the writings and the causes that come before us and emergency issues. But then the last half of the day is we deal with admin issues. So for example, if it's something like rules, say a rule that needs to be changed or needs to be looked at, we have a Supreme Court advisory board that we call SCOTX, and it's comprised of very, very wonderful, knowledgeable lawyers who look at issues that we send to them. They analyze those in great detail. And then after however long, then that will come back to us for us to review, depending on what it is. Many times we ask for public comment through the Texas Bar Journal. And all of that is dealt with. We have a specific rules attorney also. Each chambers has a staff attorney and 2 law clerks. But in addition to that, the court has a mandamus attorney that I talked about earlier, like an emergency type attorney. And then we have a rules attorney who helps with the rules. And then we have a general counsel that serves generally as our counsel. And so the rules attorney is working with that Supreme Court advisory board in conjunction with us. And sometimes those things go back and forth, and then they'll make a recommendation that comes to us. And then we decide whether to act on it, whether to accept their recommendation, whether to send it back, whatever. But there's a lot of that a lot of people don't realize goes on.
No, absolutely not. I'm guilty of that for sure. So you brought up staff attorney, and I think that's another question here that I'm sure a lot of people have as well. What is the interaction between a clerk that's there for a short amount of time and a staff attorney who's there permanently?
Well, the staff attorneys and our staff attorneys, when they're usually the staff attorneys have worked for the court, they usually have clerked. That's not a requirement, but the people who have clerked for us, our court, it's like a family. It's a great place to work. And people who work there kind of a lot of times would like to come back. And they of course have excellent credentials. They're wonderful lawyers. And they tend to stay there. I mean, one of our staff attorneys has been there. Chuck was there, what, 35 years when he just now is retiring. And that's common. Our staff attorney, they love it and they stay. And so you can imagine they have, so my staff attorney has been with me. I've been on the court 12 years and I think she's been there 8 or 9, something like that. And the staff attorney before her who left had been there for 30-something years and she retired. So, so they have a lot of institutional knowledge and they're brilliant. And so they work with the justices very, very closely. And then they work with the law clerks, largely to divvy out workload and that kind of thing to make sure that, and also determining that the law clerks are working on, say for example, I may have drawn an oil and gas case, kind of figure out which one of the clerks would be more interested in writing on an oil and gas case. Or you may have some type of a contract dispute between those two, you know, which ones, and she's the one that, at least in our chambers, that kind of deals with those kinds of issues. John, you can probably add to that.
Yeah, Michelle, our staff attorney, was just phenomenal. One of the best people I've ever worked with. And it's like the judge is saying, there's a lot of, you know, just supervisory component, but it's also collaborative. And getting back to what I was saying about opinions earlier, you know, it's not like recent law graduates are getting turned loose to, you know, write the opinions for the Supreme Court of Texas. It's very much like you have someone who serves as a mentor with more experience, like the judge said, a source of institutional knowledge that keeps things kind of like rolling in chambers. When you're cycling through, you know, there's 4 lawyers in a chambers and 2 of them cycle through every year. So it's really, you know, the staff attorneys are a source of that continuity and knowledge. And it was really a privilege to work with Michelle and the others.
And they're brilliant.
They're
wonderful.
Do the staff attorneys play a role with the study memos as well, or only the opinions?
They do with study memos in terms of I would consult with Michelle or another staff attorney just when I wanted to talk something through. But it's mostly a project for the clerks when it's a study memo.
But they can. I mean, it's not like there's a rule against it, but very rarely do the staff attorneys actually take the lead on a study memo. In fact, the only time they really do it is like right now, because right now we're in this kind of hiatus between when our old staff attorney, our old law clerks, John is now an old law clerk, stopped like last Friday before last, and our new law clerks who will start beginning of September. And so during that period of time, that's when our staff attorneys will maybe do a study memo or two, just depending on, you know, what's pressing. But generally, they don't do that. That's generally what the law clerks take the lead on. And probably at the beginning of the term, the staff attorneys have a little bit more input in it because the law clerks are new and they're trying to figure out how to do it, you know, and not to, you know, cry over the recommendation, like I said earlier, or whatever. But as time goes on, I think there's less of that and it's more, but it's also, it's very collaborative, just what is necessary on a particular case.
It sounds like it's collaborative. What a great experience. And I'm curious too, I've heard of people returning to the court later, or let's say they start practicing for 2 to 3 years and then they get a clerkship. Is that a thing? Does that happen? And I'm asking because I imagine some people on this call might be interested in clerking. Is it too late for them now that they're out of law school?
No, not at all. In fact, sometimes having other work experience, and not just in the law, maybe as a teacher or maybe as an engineer or whatever, is seen as a positive. Being a little bit older, having life experience. So no, that's definitely not a strike against anyone.
Think of so there were 18 clerks in my class, and I want to say 5 or 6 had been, you know, lawyers for several years, whether it be in government or private practice. Both of Justice Bland's clerks had 3 years of experience in private practice. One of Justice Guzman's clerks came from the AG's office. It's pretty common, and it's nice to have that mix too, as you know, go to your co-clerks who have seen a little bit more in the profession than you have to get some advice or just to compare perspectives. But yeah, it's definitely not, you know, weird or a rarity to see that.
Yeah, that's about a third. That's impressive. I wouldn't have thought it'd be that many, but that's good.
Mm-hmm. Yeah.
So I hope everybody sees in the chat, there's a CLE number. I want to make sure that you see it before you jump off too early. And then of course, if you have any additional questions, please drop those in the question box, the Q&A box. Well, and I think, John, I had asked you this, and I don't know if it's necessarily fair to ask you because you're just starting your new job, but do you have any sense for how your clerkship will help you moving forward? I mean, maybe it's just even how you think of issues and frame issues now that you see how a court considers them.
Definitely, I don't know how much I have to offer to all of these attendees with more experience than me, but just I really did appreciate, and I can see how getting a peek behind the curtain will be an asset throughout the rest of my career. It definitely forces you out of your comfort zone, which to me was always like wanting to take a side, wanting to be an advocate. Being forced to exist in that middle ground was a challenge. You're it's not that you work backwards from a conclusion when you're an advocate, but you definitely have to exert effort to remain neutral. And that was a skill that I appreciated. And I think it has benefits, hopefully, once you transition to advocacy in private practice.
Well, I'm sure it would. With our last few minutes, I say that because I'm one of those people who I'll read a brief, like, oh, this is really good. And then I'll read the other one, oh, well, maybe not so much. So I think it's great that you have that skill for sure. With our last couple of minutes, are there any tips, any pointers that you can give to our audience about anything relating to Supreme Court practice? I know that's pretty broad, but any last words of advice we'd really appreciate.
John, you go.
I think the only time I ever saw anything that I would call not good come through was just when parties didn't know when to stop, whether that be, writing or hammering on a point in an oral argument. To me, just like putting things simple and brief is always a good thing. That might be personal opinion, but like and there's a way to do that no matter how long the brief is. Like some of the best briefs that are 45 pages, they still read snappily. They just have a lot of ground to cover. So that's something that whenever I would read a brief by some really experienced good lawyer that walked that perfect line between like brevity and depth, I would put it on my desk and refer to it as like, this is good writing, remember this. Because to me that just the writing in the case is just so important. It gets looked at by every judge, by every clerk, by every staff attorney. And when you base it all on that, it looks like it has good results. So I was inspired to see all that great work that came through and trying to learn whatever lessons I could from it.
Thank you. What about you, Justice? Do you have any last parting words?
Well, first of all, I want to say, I think that John's was really, really good. And it's also hard because, we talk about the necessity to get the hook, to be succinct, realize how much we have to read, blah, blah, blah. On the other hand, you don't want to pass something up because you've got waiver issues. And so that's always a fine line. If you throw too much on the wall and you have, 20 different issues, it tends to make just your initial responses, there must not be anything here or they wouldn't be throwing so much on the wall. On the other hand, you don't want to waive it either. And the court becomes, is concerned about those kinds of issues. So it's hard. So I really appreciate John's commenting on that. Mine is just a more general idea for people who are starting out as young lawyers. And I think, we all talk about finding our passion, find your passion. And that's great, for the lucky few that know what that is. But, most people just don't know what their passion is, especially when they're young lawyers. And so my advice to people on that is don't sweat it. Don't worry about it. Do the best you can at everything you do. Work hard. Know that it will be noticed. And in the long run, it's going to pay off. When I was a young lawyer, if you would have asked me, am I going to serve on the Supreme Court of Texas in blank number of years, I would have just started laughing and falling off my chair. That just was not what I thought was going to happen. But here I am. And so I think that it's not like I have this passion, I got to serve, you know. I did, though, have a real commitment to always do things as ethically as I could, to be as honest as I could, to work as hard as I could, and to try to do the best job I could at whatever I was doing. And when you do that, I think a lot of luck is involved too. Obviously, timing is everything. So I'm not trying to suggest that everything's going to work out exactly how you may want if you have a plan, but it'll probably work out pretty well as long as you follow those basic ideas and just don't get too caught up in not knowing exactly what you want for your future, because a lot of people don't.
That is so true. Still figuring that out myself. Well, both of you, thank you so much. This has been a wonderful session and a wonderful last session at that. So thank you for helping us close out, getting to know the courts. And
Thanks
with
for having
that,
us.
we can end.
Thanks for having
Thanks
us.
so much.
Absolutely. You have a good afternoon. Thank you, everyone, for joining.
Thank you
Bye,
so
all.
much.